An Ohio city passed a law with 17 abortion-regulating provisions. The United States Supreme Court considered the constitutional soundness of 5 of those provisions in 1983's Akron versus Akron Center for Reproductive Health. In February of 1978, the city of Akron, Ohio, passed a law with 17 provisions regulating the performance of abortions. Notably, one provision required all second-trimester abortions to be performed in a licensed and accredited hospital, as opposed to, say, a clinic. A second provision required parental consent or a court order for unmarried minors' abortions. A third provision required patients attending doctors to personally recite a lengthy, inflexible list of information to secure informed consent. A fourth provision required a 24-hour waiting period between informed consent and the procedure. And finally, a fifth provision required doctors to dispose of fetal remains in a, quote, humane and sanitary manner, unquote. Together with other plaintiffs, the Akron Center for Reproductive Health sued the city in the Northern District of Ohio, challenging the constitutionality of those 5 provisions. The district court struck down some of the provisions, but upheld others. Both sides appealed to the Sixth Circuit. The Sixth Circuit struck down the provisions dealing with parental consent, doctor-only informed consent, a 24-hour waiting period, and fetal remains disposal, but upheld the one dealing with second-trimester hospitalization. Once again, both sides appealed, this time to the United States Supreme Court, which granted cert.